Parviz Ravi, attorney at law, have been practicing for over 20 years. Our office is located by San Francisco Airport, specializing in employment law. Today's topic, pregnancy disability leave in California, part one. In California, there are generally two types of maternity leave a woman can take: pregnancy disability leave and the baby bonding leave. Of these two, pregnancy disability leave is the most common because the eligibility requirements are much lower than baby bonding leave. In general, pregnancy disability leave is the leave a woman takes while she is disabled by her pregnancy or the childbirth. Under California law, if you work for an employer with 5 or more employees and have a disability related to your pregnancy or the birth of your child, you can receive up to 4 months of maternity leave while that disability continues. You are entitled to this maternity leave regardless of the length of your employment, whether you are full-time, part-time, or even have been recently hired. Also, California pregnancy disability leave does not need to be taken all at once. Rather, it can be spread over the course of pregnancy and childbirth. The most important question for women is whether they are, in fact, disabled by their pregnancy, the childbirth, or a related medical condition. In general, pregnancy itself is not considered a disability. But if the pregnancy-related complications arise, you may become legally disabled. Some examples of conditions which are commonly considered disabling enough to qualify you to take your pregnancy disability leave are as follows: severe morning sicknesses, prenatal or postnatal care, which involves issues one experiences before and after birth, the need for bed rest, high blood sugar diabetes caused by pregnancy, high blood pressure caused by pregnancy, postpartum depression, a mental health condition that can occur after giving birth, loss or end of pregnancy, and recovery from loss or end of the pregnancy. Under California law, once the pregnancy disability leave is over, you can take an additional 12 weeks off to bond with your child. This is called parental or bonding leave. However, it is only available to employees who work for the employers within at least 20 employees. If you have used up all of your entitled leave, but you're still unable to work due to physical or mental condition, you might qualify for additional time off. California law requires employers to provide reasonable accommodations to employees with disabilities. One form of reasonable accommodation might be more time off if it will allow you to return to your job in the foreseeable future. If your employer denies you pregnancy, disability, or family leave for which you're eligible, your employer may be discriminating against you. You may wish to contact a labor law attorney to make sure that all your benefits and entitlements are protected. It is very important to know that if you take the necessary time off from work, you won't lose your job. Remember, your rights as an employee are protected by law, and you have the means to take action if your employer fails to comply with the regulations. So stay informed, know your rights, and advocate for fair treatment in the workplace. If you have any questions on this topic, please contact my office for free consultation. Please be sure to like and subscribe and turn on your notification.